Yes, so it is combination of criminal law and process. So as we look at the syllabus, intention, purpose, subjective, objective, all the first components are about the mens rea itself, and they are about different type of offenses, how to interpret different type of offenses, and we are also trying to understand further who else can be in the picture. If I'm your friend and I'm not your friend, lawyers don't get into trouble, that's a very bad example. We are very smart people, and we are very kind people and law abiding people. So let's talk about our client who was with his girlfriend's house, who was at his girlfriend's house. What if his friend came there to give him drop some food, or drop some bottles of alcohol or something like that? What is the liability of that person? So now the cops are questioning his friend as well. So his friend can be our client at that moment who needs help. Why? Because he can be charged with aiding and abetting in the offense, right? He can be counselor of the offense, and he could be some other extension of liability in the conspiracy theory, or some other kind of liability as well. So we have to think from all the point of view and all the angles in this subject. Another thing is, we have different type of offenders. Individuals are offenders. Healthy human beings can get into trouble with law. Corporations can get into trouble with law. People can commit a crime, but they can be of a diminished capacity. So they can be mentally incapable person who has been charged with an offense, who committed a criminal offense. So we have to see mental disorder as a defense. Or another thing in criminal law is about somebody who was fit to commit a crime, but then the next component is the next step in the process is he is now not fit to he's not considered fit to run his trial, because in criminal law you cannot have litigation guardian and have somebody run the show. It's the person who is involved has to run the show, right? So he has to understand, instruct the lawyer and everything. But if that is not happening, that we have the guy who is not fit to stand the trial, not fit to stand trial. So then we would have fitness to stand trial would be another process in this thing, right? So we are talking about different type of offenders. So offenders can have aggravated factors, or offenders can be minors as well. So we will understand we have a YCJA law which takes care of good morning, Angad, please keep your call on the mute.
Yeah.
Thank you. We'll have a live session in the end so that we can answer the queries. Now, so we were talking about the types of offenders we can deal with. We can deal with individuals who are absolutely fit. Unfortunately, they are going through the bad phase of their life. They've been charged with an offense. Then we can have corporations. We can have mentally incapable person. We can have a perfectly healthy person who is not now fit to stand trial due to their current mental health issues. We can have minors. We can have youth offenders, that is, we have a law called YCJA. Another thing we have is, then the next component is the circumstance of the individual. People can have mental health issues, so they can have a defense of mental disorder. People can have drugs. They can have aggravative, so they can be Controlled Drug Substance Act can be involved in the process. CDSA can be involved. There can be weapons involved. There can be intoxication involved. So we have to see what type of the circumstances of the individual would, or the key other areas around the circumstances of committing an offense. We will see what is the degree of responsibility, what are the other factors. So we have to see, understand all the things, and then list, and then the next job we will have in the exam is trying to interpret it and rule out or apply certain things. Now Bigger thing, we have one key component is defense of the person. That's absolutely subjective situation of a person. That can be why would somebody commits an offense, or they felt compelled. It can be defense of a person, necessity, their circumstances dealing with duress, provocation, entrapment, and somebody can be, committing an offense under wrong impression. Somebody sincerely believe that he can do it. We know that mistake of law is not a defense, but mistake of fact can be defense. But in Canada, we have a color of right. It means if I'm coming to your house and after the party I took your coat and you charge me with accuse me with theft, then I'm saying no. Actually, this is the same brand and the same color coat I have, so I sincerely believed it's my coat, right? So that's why I took it. I didn't steal your coat. That would be color of right. So these are the circumstances of an individual, the things happening around the person. Then we will see how criminal responsibility change in the picture. Next thing we have is, this is the law component. We will understand the Canadian law. We will understand slowly how everything is a specific test in criminal justice system in Canada, and of course in criminal law we will see how something is established or ruled out, right? So we have the case laws, and my best friend in my criminal studies or my administrative law studies and my constitutional law studies has always been, I'm going to introduce you to my best friend. This is what it is. It's criminal judgments or constitutional judgment or administrative law judgment. I've always been doing through Supreme Court of Canada. So this is my favorite platform to study. That's how I teach. Some of you are my students, and so you know that how I teach directly from the line of fire, so that we learn from the masters of law, our Supreme Court of Canada judges, who have laid down beautiful judgment. I would consider it beautiful because every time I read it, I fell in love with the way they teach. So basically, to learn any subject, you can just go to a judgment and read it from A to Z, and you don't have to worry about IRACs, you don't have to worry about anything after that, because that's the way they discuss an issue. They teach you from A to Z. So we will be also, in my live classes, I also take care of teaching and highlighting to my students, like, see, this is how. So we can towards the end, we can also run a mock session for ourselves, so that you can feel empowered, and you can learn how to read a judgment, right? So in criminal justice system, we were talking about, we have an accused. We talked about the accused. We talked about the circumstances of the accused. We talked about the basic defenses of the accused. So, and other laws, like if weapons are involved, drugs are involved, and all that stuff. Now, who are the other key players who are involved in the process? It's the defense lawyer, it's the Crown Counsel, it is the cops who make sure that there is a public peace and order in the city or in our country, and we will understand what are their responsibilities, how they run the show. So the next thing we have is the judges. So we will see how judges run the show, how judges filter the law, and when jury is involved, and how trial is handled, and what is the discretion of the judges, what is the role of the judges, and all that stuff. So as I said in the beginning, criminal law is all about criminal law as well as criminal procedure, right? So rather than thinking, oh, these are 30 points in the syllabus, I have to read so much. So break it down, always break it down, read in the syllabus and see. I would say, take an A4 sheet, write the key players, then divide the chapters and divide the thing, your information into those key components, so that your brain is, wired from day one to understand the subject in a major key areas. So I always say, like, what are the 5 or 3 big things we take in the picture? So in criminal justice, if we are talking about the criminal law as our subject, the first thing you will ask yourself is, So these 10 points of the syllabus are responsibility of the defense lawyer. These 10 are the responsibility of the Crown Counsel. These are the in-between key players, and then you break it down into further components. So this is one very good tip to understand and not get overwhelmed in the syllabus. So whenever you're reading, you're applying your standards, you're reading the notes or the books or anything, you should always come back to those 5 or 4 bigger points. Even in the revision right before your exam, it'll be highly beneficial for you, because you have trained your brain to kind of say like, oh, I know now today for your next 3 days I'm going to prepare as a defense lawyer only. So this is the cues, and that's how we're going to run the defense component. So as we said in the beginning, we have a bigger player, that's our cops. So, and in Canada we have Constitution of Canada, right? So Constitution of Canada provide criminal justice rights in charter. So when we look from section 7 to 14, we go through different charter rights. If somebody's been detained, they have been arrested, right to bail, right to trial, fundamental justice as enshrined in section 7 is there. So we'll learn if in the process all those fundamental human freedoms have been arbitrarily denied or violated, then what is the right? So then the remedy is provided in section 24 of the charter. Section 24 of the charter 24(1) gives wide area, it's a very big discretion of the courts to decide what to apply in a certain situation. It can be stay of charges, it can be must have heard about Jordan application, in which they talk about there is an ultimate ceiling on the trial. You cannot run a criminal trial for a very, very long time, and criminal justice system provides upper ceiling after Jordan case about the criminal cases, how long a trial can run. So if it's run from a ceiling period more than the ceiling period, then there would be a stay of charges. So then that 24(1) has all those innovative remedies which the judges believe. It can be an adjournment, it can be cost, it can be stay of charges. So those can be provided in certain circumstances. And section 24(2) is a very high threshold remedy, which says whenever any evidence, section 8 of the charter says people have in Canada we have a protection against unreasonable search and seizure. So if you've been searched wrongly, what would they get? They would get a piece of evidence, and that evidence, as per section 24(2), can be what is the word? Give me a second. Section 24(2) provides any evidence which is violation of charter is not admissible in the trial if it brings administration of justice into disrepute. So how do we say and understand administration of justice into disrepute? How can we break it into layman's terms? So see, a person is selling drugs right outside the children's school. So that person is somehow wrongly he was caught in a random search by the cops, and now he was saying no, you know what, they violated my charters, I have a protection under section 8 and under the search and seizure. Then the court's gonna weigh his charter rights as the society's interest in the administration of justice. So we will see whether that person's right under section 8 has been so violated that it brings the administration of justice in our country into disrepute. If it does, then we're gonna exclude it from our trial. If it not, then it's going to stay in the trial. So it can be, so we will see administration of justice is a filter in section 24(2) which provides whether an evidence is admissible or not admissible. So we are trying to understand the charter rights. So every encounter with the cops, every encounter with the criminal justice system would trigger section 7, 8, 9, 10 or 11 or 12, whatever the case is. So we have to see those are inherent things in our system which protects that people, even if they have committed a crime, they have a right to be treated on a constitutional standard in our country with criminal justice system. So then we have the case laws and understanding, and they have rights. So criminal justice system, we can say it's a one-way traffic. You accuse the person that you are guilty, and then we will see that this person is guilty of this case, and this person is have to be proven beyond reasonable doubt. So the person has to stay quiet until unless his position in the, so we have a adversarial process in our country. So in that, for that reason, we will see the person has to be proven guilty beyond reasonable doubt by the crown before he starts his own defense in the picture. If the crown's case falls short of that standard, then there would be a directed verdict, and they would the prosecution fail at that moment. So next thing we have over here is, we are trying to understand the accused has rights. The accused has a right to know the case. That is called disclosure on criminal justice system. Then we have a jury trial. As I said in the beginning, we in the justice system, we also have pre-trial applications. Then we have sentencing. Sentencing has its own criteria, and sentence hearing would play how the cases are. In criminal justice system, we have the sentence hearing. In the sentence hearing, there are threshold as laid down by section 718 to see how the criminal justice system would decide whether this person should go to the higher punishment or a lower punishment or whatever, right? So I have one big thing to tell you over here. From day one, every offense you read, whether you're reading my notes, some other notes, you're reading in a book, or you're reading anything, a judgment or this thing, make sure you have one tab in which you tab the particular offense you're dealing, right? Supposing you are reading a news item and you say, oh, somebody committed an offense under section 244.2 of the criminal code. From the day one, when you start reading your criminal code or criminal justice system or criminal law syllabus for NCA, you have to fall in love with your code. So you need one particular sticky or tab to tab all those offenses which you come across. So there is no end of learning of the different offenses, right? So then when you start reading, next thing we have to have is two highlighters. One for your actus reus, one for your mens rea. So when you start reading the code, when you read a news item, you will see it can be a judgment, it can be an article. So you don't have to learn directly from your syllabus or from your books or anything. So the best thing to learn criminal, have control of criminal syllabus is start tabbing as many offenses as you can. Learn about it and see what is the threshold. Are they summary? Are they hybrid? So you need to break it down into three things. Are they hybrid? Are they summary? Or they are indictable offense. These are the types of offenses. So you need one highlighter for type of offense or one short note where you make scribble on your code. Do not start studying before you have a proper code in your hand. This is your best friend from your day one. And the next best friend you have in your study is your criminal your offenses. You will start tabbing the offenses from day one. So you are reading about, say, abduction. You are reading about somebody they took care of his somebody didn't take care of his children, or an old person or something like that, and they neglected a legal duty. So you will see how that offense has been interpreted by Supreme Court of Canada, what is the law behind it. If you read a news item, make sure you come back to your code and tab your code. This is your best friend throughout the process. It will take lots of burden off your shoulder of your criminal studies, because then you are not saying, oh, now in the last 5 days I have to learn everything and absorb it and review it. So in exam you might come across any offense. So reading the code, learning how to break down the code, you can self-learn by keeping the code handy from day one. and reading. Whenever you read anything, come to the code, break it down and see how can you read the code. So what are we learning? We are learning actus reus, mens rea, knowledge, a word related to mens rea, so how it is being interpreted in the code. The next big thing is how it is interpreted by the Supreme Court of Canada. So you have two best friends in the process. One is your code, and next thing is this wonderful resource, Supreme Court of Canada. I would say don't read any summary of the judgment, don't read anything anywhere else. Start reading directly from you have enough time till January. If you read 2 judgments in your first week, it will be very difficult at the beginning. You might find it hard, but once you read 2 judgments, you will see how wonderfully the law has been discussed from A to Z in one judgment, and it itself is a teaching resource. It's been always my favorite resource. I learned all the cases, everything self-learned myself. So the self-study, the basic thing is falling in love with the code, keeping it handy. Don't chase too many IRACs, don't chase too many notes or something. Stick to one resource and experience converse yourself more and more with reading different type of offenses and coming back to your code and referring to it. It can be any, it can be Martin, it can be Tom, it can be any other code. They're all good. So now the Supreme Court of Canada is a big resource. You go read the judgment, and you would see how wonderfully the law has been laid down, and this is another wonderful resource to understand how we can empower ourselves in our self-study for the law. So this was my basic introduction of criminal law. That's what I thought. If I knew in the beginning of my journey, it would have been amazing for me. It would have been much easier for myself. So I hope this introduction and this webinar helps you to feel comfortable with the subject, not just saying, oh, I have a lengthiest subject. This syllabus itself runs for 30 pages. It's just too much. No, it's not just too much. Try to break it down into basic things, and I'm here to help you. If you have any quick question, you don't have to be my student to ask me one specific question. So you can always throw a message and say, go, this is what my concern is. Can you have, if I have too many questions coming from other people, I run webinars time to time so that I can help people to understand and feel empowered in the process. So this was my introduction for criminal justice system and introduction from your NCA criminal exam. I wish that this helps you to understand and feel a little bit more comfortable in the process, and you feel empowered, you feel more self-reliant, self-confident in the studies. And my classes are run all year around. I love teaching, it's my passion, and I'm happy to make your journey as easy as possible. It's challenging, but it's worth it. So I'm here to answer any questions or queries you have from this, whatever I talked about, and you have any concern about this. So we can start, anyone can start asking me questions. Prem, you joined late, so do you have any question? If you think you missed something, I'll be happy to answer. Go ahead, please.
Just generally, I don't know it's right or it's not correct. Now they have shifted their approach. I believe they have making question papers very strict, or you can say very tough to clear it. Is it?
No. There is no such thing as too much. Somehow I always feel the exam is a very fair standard. So I don't think so. I think it's because when I started studying, we had no IRACs, we had nothing. So we learned from the scratch, right? So I was in India and I had no other resources than my code and then the Supreme Court judgments. So I read those judgments, and I believe my exam was, a little bit. It took me some time to understand what they're trying to teach us. But if you read, this is what I'm encouraging, read from the best source. If you read from the best source, there is nothing which you don't know in the exam. So I would say don't worry about the questions or anything. learn what has been provided us to learn. So if we learn that and we are comfortable with that, and I don't think so any exam can be too tough. We are all lawyers here. We understand how judgments, how can be read, how criminal justice system works. Some people find it a little bit hard because they are coming from, say, corporate law world, and somebody has law degree but never had an experience of trial. But if you then you have to like a little bit see what type of resources you need. So I would say you should not worry. You should rather work more on your preparation, and don't worry about the exam. I wish you good luck, and I wish don't worry about the questions. The questions cannot. Question is, the law is evolving every day. Law is changing every day. There's so many things coming and so that has to be added in the syllabus so that we are aware, right? That's the same way the questions has to be a little bit changing on the subject. So, but I don't see there is any mens rea for us in this process. So it's a very fair system. Yes. Anybody else?
Yeah. And ma'am, this is a 4 hours pre-push answers. Like,
yes,
the
for
timing is
January,
so
luckily we are blessed that they have extended, understanding that everybody is not very comfortable in typing the exam, and so they have and people have been this is a very good opportunity for you to write the exam in a 4-hour format. There is more than enough time to write the exam. Yes. Any other question for me? Mandeep, you have.
Hi.
Hi.
In terms of examination.
May I know your name first?
My name is Prasanna.
Oh, hi Prasanna. How are you?
Hi. I'm good, thank you. In terms of exam paper, do we focus any specific area of the subject, or does it consist of does it cover the whole syllabus?
So I would say so for the way I prepared for my exam, and that's how I train my students, we do everything. So we never go for any specific areas, or this has never been part of my style. I believe in hard work, and I believe training to the perfection. So no matter what you've been quizzed, if you've learned things, you can definitely demonstrate what is asked in the exam.
Okay. The other thing is, if we participate to your regular classes, could you tell us how much we have to pay?
Yes, of course. I'll be sending you my follow-up email, and my staff is working on my schedule, and they will. The purpose of this class is to basically help students who are find myself a little bit too busy at times, so that I can make you feel empowered and help you with your self-study, so that you feel good about and feel more focused and more in control of your syllabus. So that's the purpose. But I'll be happy to have you in my class as well, and you would be getting please private message me, or in the group you can leave, or you can go to my page or my website, Canadian Law Tutor. You can leave me a message, and I'll be happy to provide you the follow-up. I'll make sure you receive an email about the classes and the details.
Thank you.
Yes. Any other question? Mandeep, do you have any question for me? We have Komal. Komal, do you have any question? And Bhavna is Asima. Yes. Anybody? Go ahead, please.
Yes, I have a small question. How do we go about the criminal code reading? Do you have enough time during the exam to read the criminal code?
Yes, there would be enough time in the exam, because you won't be asked about the whole code, right? So there would be 1 or 2 sections within one question which are applicable. There would be one offense, one basic definition, and then if what we call that weapons are involved, then we look at those offenses. So I don't think so there is anywhere more than 2 or 3 sections involved in one particular questions. So you don't have to reproduce the code. You just have to refer to the code and apply the code. That's what I always encourage reading Supreme Court of Judgment, so that we'll see how they break it down and apply it.
So they were considering the logistical issue that we are not physically in Canada, how can we get access to the criminal code in India?
I would, look for the other students who have the code, and I printed my code. But I also did it in my India. I did my printout in the code, printout of the code. So you can have a PDF copy, and you can message me. I'll guide you how to get a key PDF copy, and then you can print it.
So it could be the normal version that you have shared on the group, or should we
Yes.
refer to the student version?
No, you can use any version. Don't worry about the version of the code, because end of the day language is the same, right?
Yeah.
It's just more quotes or
Thank
something
you.
like. No, you're welcome, Komal. Yes. Anybody else have any question for me?
Hi, girl. This is Komal. Can you hear me?
I can hear you perfectly, Komal. Good morning or good evening?
Oh, it's good evening. So I'm in Mississauga.
Wow,
Right now.
wonderful. I love Mississauga. So can you see?
Where are you located?
You will get my access when you address when you are sending me Christmas card.
Okay, so we have December 25th.
Yes, so before that you'll have my address and you can send me, since we are recording, so I don't want to. Yes, go ahead please with your question.
Okay. So my question is just a bit different.
Yes,
From tomorrow for sure, I'll be attending your contract session as well. So
right,
I'm intending to write contracts and criminal with
right.
TOTS in February. So
Wonderful.
TOTS, yeah. So like as you have the entire knowledge of this syllabus right now sitting there, what do you think? Reading so much and doing self-study, is it advisable to take 3 subjects which are really heavy?
No, there is no. It really depends upon your person. I would say, see how much time you can devote to study, right? Because if you're working full time and you may not be able to do it, but I believe NCAs can be handled with the work, because I always get students who are writing 4 or 5 and they're working full time. So Sarah, you wrote 4 exams in the last sitting and with working full time, so I believe it's definitely doable. So
Okay, so just a little background about myself. I have just completed my law degree, but I'm also an engineer, and since 5 years I worked in IT.
wow,
So
so you
I'm
need a little bit time to, that is what, and these are the, students who definitely need a little bit of help with the classes so that you can understand how things work, right? So if you're a lawyer coming from a trial lawyer with the experience of 10 years, then you don't need anything, right? So you just have to see how Canadian system work, and you just try to, learn a different system. But if you are from corporate world or IT world, then you of course need a little bit. So then I would recommend you should go for classes where somebody can actually like me, who can break it down and make you feel more comfortable in the process. So but writing 3 exams, I don't see there is any problem with that. I normally work with people who are writing 7s, 5. I completed my NCA in 1 sitting, no, 2 sittings. I wrote January I wrote my 1 exam and I was assigned 2 more. I was only given 3 exams, and I basically finished my NCA in 5 months. I don't see this is, I'm very pro hard work and pro let's go for it and you can do it. So of course I think and every task looks huge until unless we have started it, but one thing at a time, and we should be able to navigate this through this process. And tort and criminal, they have like a little bit of overlapping of mindset, so you think from the same level of responsibility. One is criminal, one is civil, so I would say it's a very good combination. And contract you will understand, because contract is very much common sense, and with the way the contract in the practical sense, which it's applied in every day, everything is contract. So we go buy a ticket, we go order something, that's also a contract. So I would say contract should be, it's not that heavy a subject.
okay, hopefully, let's see. Tomorrow I'll see the syllabus of contracts as well, and
Yes.
hopefully I'll dive in.
Yes, you will dive in and believe in yourself. The biggest key in this process is always believe in yourself, right?
Yeah.
So any other question for me? Angad, do you have any question for me?
No, I think you always answered. Actually, I wanted to point out what Komal just asked. So I think that pretty much answers my query also. I was actually coming up with the same query because even I'm planning to give contracts and criminal in the Jan sitting. So
Yes,
I
that's
was
doable.
confused, but then yeah, I mean you've laid down your thoughts on that.
Thank you. Anybody else? Any question?
Did you recommend us to buy any books, or are you going to provide notes to?
I am very pro books. I would say, books are your best friend. I learned from the books. I learned from Supreme Court of Canada judgments. I learned from the code. So I believe in that. So yes, I provide my notes. I give my breakdowns, but those are ancillary materials. But I definitely recommend books. I don't say that you don't need books at all. So we can personally see when we have in the classes how we are going, and you have sometimes in the classes you have all the information from your fellow students, so then you might not need it. But as far as my personal opinion is concerned, I'm a very pro book, pro code, and pro Supreme Court of Canada judgments. So I believe in the raw resources. Yes.
Thank you.
You're welcome. Hi. May I know your name, please?
My name is Vikas.
Oh, hi, Vikas.
How are you, ma'am?
I'm very well. Thank you very much for asking. And I'm really excited and happy in this session, and I hope you find it fruitful. Go ahead. How can I help you?
I got too many things which I already jotted down on my copy regarding the flags or colors.
Thank you.
I don't know about how to sort out this thing because it's not easy to read all the material in one go.
No, you don't have to read all the material. Let's see. We can do that in specific classes when we go along, and I hope I can help you. But right now, you can ask me any other question you have. Go ahead, please.
My second question is that is it possible if one person is giving the exam in January, so he can give the exam in February too for the second go, like CPR?
I would say as I've been a bit busy to read all the rules which are coming in recently, so I may not be able to give you the opinion, but my opinion is qualified. But my basic understanding over here is when they have given us the breakdown from January to December, I believe the only rule I remember from NCA is once if you do it in the one sitting, you cannot write it. If you fail the exam in the one sitting, you cannot write in the next sitting. Normally now the syllabus result doesn't come with up to the next sitting, so there is no way you can write it, right? So I would say you can definitely lay it down. I think they have given us a very good breakdown to understand and plan our subjects as you want to write. I don't think so writing in January or January and then February or March consecutively would change anything for you.
Okay, it means I can do that.
I believe so, as far as my personal logical understanding is.
Because for the CPR registration, it would be started on the 16th of December, I think.
Yeah, so I think make sure you register on time. I don't see there should be any trouble with that.
Okay. Thank you, ma'am.
Yes, go ahead.
It's just over.
No, your problem. Go ahead. Any other question? Bhavna, you have question for me?
No, I got my answers. Thank
Good,
you.
wonderful. Yes. Sarah, do you have any question for me?
No, I think you've covered what you needed, what I wanted to in the syllabus. No, I think that your teaching style is great, and it's sort of got me through a lot. And I'm hoping to carry on studying with you for the remainder of my subjects, which I hopefully we'll be finished in, as you know, February.
Yes,
So
we'll be
I'm
done.
relying on you. You're awesome. Thank you.
Thank you very much, and thank
Yeah.
you for joining my
Awesome.
session.
Yeah.
And I hope I have helped you guys. And if you need any further help from my you can from my team, you can message me. You can send me what I have created a WhatsApp group so that we can have a more flow of information, and I'm always here to answer your queries. I wish you good luck. I'll be posting about my classes as well. You are more than welcome to join, or if you are self-studying, the purpose of this basic class is to empower you for self-study. So self-study is the best tool, it's the best way of learning, and if you feel overwhelmed in the process, the help is right there. But it's doable process, it's challenging, but it's worth it. So just see, I would I would like you to take something from this session is, look at me. I started this journey 10 years ago. Look at me, how far I have come. I had no resources. I had, not much help. But right now you're living in a, well-connected world where there are more options, more opportunities, more learning resources are available. So believe in yourself, gear up for your studies. You can go way far ahead than me. So your journey is starting. Just see how big you can be in next 10 years, and this is where I would love to see you, and I would like to receive a message 10 years down the line. Hey girl, I was there in your class and now I'm here. So I would be very, very happy to see you thriving in the legal world. And I know this journey at this moment looks a little bit overwhelming, but let's keep working together, let's help each other so that we can feel connected, feel empowered, and there are resources out there for your help. Thank you for coming to this class and be able to give me this intellectual session. It's always so exciting to meet wonderful minds, and may you become a wonderful criminal lawyer.